I'm Drew Stevenson. This is for my administrative law class. Here I'm going to be talking about ACLU versus CIA. This is a DC Circuit Court of Appeals case from 2013 about the Freedom of Information Act and what we call Glomar responses. So let's dive in. In this case, the ACLU had filed a FOIA request for records relating to the use of drones and drone strikes, unmanned aerial vehicles, for targeted killings by the United States government in countries overseas. So the CIA, in response to the ACLU's FOIA request, could have invoked one of the existing FOIA exemptions, like Exemption 1 for national security secrets and classified documents, but instead they issued what's called a Glomar response, which I'll explain in a moment, and basically refused to confirm or deny that they even had documents related to overseas drone strikes by the U.S. government. And the district court had actually agreed with the CIA in this case and had granted summary judgment in the government's favor. A Glomar response permits an agency to refuse to confirm or deny the existence of records or recorded information in limited circumstances. Basically, only when answering the question of whether they have the documents would itself cause harm cognizable under another FOIA exemption. In other words, they really can't reveal whether they even have that information, because answering that question would create harm under another FOIA exemption. For the Glomar Doctrine, courts will normally apply general FOIA exemption review standards to determine if the existence or non-existence of the records would fit one of the 9 statutory exemptions. This type of defense that we call the Glomar Doctrine really originated with a 1976 case, Phillippi versus the CIA, where the CIA first refused to confirm or deny records related to vessels that had reportedly recovered a sunken Soviet submarine. So when an agency has already officially acknowledged or disclosed some information that would otherwise have been exempt from disclosure under one of the FOIA exemptions, it waives its ability to claim FOIA exemptions for that information later on if a party requests it. And this means that disclosure could be compelled by the courts if the information has already been acknowledged publicly by someone in an official capacity, and the plaintiffs will have to point to specific information that's in the public domain. So the Glomar Doctrine and the official acknowledgement doctrine collide in this case with ACLU versus CIA. The plaintiff is using an official acknowledgement to rebut the CIA's Glomar response. And the specific information, remember, is whether such records exist, not their contents. So we're not arguing about whether drone strikes are good policy or are moral, or whether the strikes occurred or how often or where, just whether the CIA has records of them and whether the CIA needs to admit that they actually have records. If they do, then we would move on to a different FOIA exemption. Just so you understand the standard of review here, the court is going to conduct a de novo review of the agency's use of a FOIA exemption. So courts will give some weight to an agency's affidavit that details the classified status of the disputed documents or records. Now, even though they're conducting de novo review, the standard is a pretty low threshold for the agency to meet. Courts will consider the agency's justification for invoking a FOIA exemption or giving a Glomar response where they just refuse to acknowledge whether they have the documents. Though courts will consider that sufficient if it appears to be logical or plausible. Now, here, the CIA claimed that denying or confirming whether such records existed would reveal whether the CIA was involved in or had any type of interest in overseas drone strikes. And the agency was going to claim that the CIA's information about drone strikes was exempt under FOIA Exemptions 1, which is about national security and classified documents, and 3, which is where there's other law or statutes that have created very specific exemptions. The CIA declaration stated that this fact was currently improperly classified and its disclosure, quote, could reasonably be expected to cause damage to the national security, end quote. That was their assertion. Note that the CIA's Glomar response was really broad. They were refusing to confirm any documents about drone strikes, not just those that might have been operated or conducted by the CIA itself. They claimed that acknowledging the existence of any documents at all about military operations or anything else would reveal the CIA's intelligence interests in that region, and they were refusing to do it. So the plaintiffs in this case, the ACLU, brought up a number of public disclosures or statements that had already been made that seemed to undermine the CIA's Glomar response. And we'll start with President Obama's statements and speeches and addresses. The president had publicly stated the U.S. was using drone strikes against al Qaeda, and he had emphasized their precision and effectiveness in targeting al Qaeda operatives. John Brennan was one of President Obama's counterterrorism advisors, and in his public speeches or statements or interviews, he had publicly confirmed that the U.S. government, quote, conducts targeted strikes against specific al Qaeda terrorists, sometimes using remotely piloted aircraft, often referred to publicly as drones. Moreover, John Brennan, this counterterrorism advisor to President Obama, had declared that the administration's decisions would draw on the, quote, full range of our intelligence capabilities and involve asking the intelligence community to gather additional intelligence and analysis. And obviously that includes the CIA. So there's no question that the CIA, according to the White House, had been consulted about these drone strikes. And then we have CIA Director Panetta, who said, quote, obviously, because these are covert and secret operations, I can't go into particulars. I think it does suffice to say that these operations have been very effective because they've been very precise. And he continued, our tactic is very precise and is limited in terms of collateral damage. So the court looked at these types of statements from the president and a national security advisor and CIA Director Panetta and said that they're tantamount to an acknowledgement that the CIA has documents on this subject. The content of those documents remains to be seen, but the CIA can't keep pretending that they may or may not have documents. They were obviously consulted and obviously have a lot of very specific details about these strikes and the casualties. So these public statements from the people in the White House or the administration led the court to say that the CIA's averment is neither logical nor plausible. Remember, that's the standard for Glomar defenses, given the statements by the CIA director and the president's counterterrorism advisor. According to the court, quote, the only reason the agency has given for refusing to disclose whether it has documents is that such disclosure would reveal whether it has an interest in the drone strikes. And it's now clear that the agency does have an interest in drone strikes. And so it beggars belief that it does not also have documents related to the subject. So in the end, the court held that the CIA's broad Glomar response was untenable, and it reversed the district court's judgment and remanded the case for further proceedings. I pulled out a quote that I liked for those of you who like to underline or highlight in your casebooks, where the courts concluded the CIA asked the courts to stretch the doctrine, that's the Glomar Doctrine, too far to give their imprimatur to a fiction of deniability that no reasonable person would regard as plausible. So on remand, now the district court should decide whether FOIA exemptions 1 and 3 apply to the contents of those documents. And so how is the court going to decide whether the contents of the documents? Well, We call this a Vaughn index or some other type of document that describes the classified documents, at least in general terms, for the court to decide. It gives just enough information for the court to determine whether it should fit under a FOIA exemption. This case, ACLU versus CIA, is a really nice example of why Glomar responses are one of the hardest types of legal disputes that we have in the national security area. I want my students to be aware that Glomar responses are also common in law enforcement cases, let's say, that are asking for information from law enforcement agencies, often rooted in Exemption 7C, which protects records compiled for law enforcement that could invade personal privacy. And what ends up happening is the law enforcement agency does the same thing. They say, I can neither confirm or deny that such records even exist. Sometimes this works. Courts have held that FOIA Exemption 7 for law enforcement authorizes Glomar responses unless the public interest in disclosure is strong enough to justify the privacy invasion. That brings us to the end of our brief discussion about ACLU versus CIA. Thank you for watching.